So, friends, the Supreme Court just conjured up absolute presidential immunity right out of thin air. So, yes, things are dark on the democracy front at this moment, but we're going to talk about the silver lining, how and why there's still hope. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, today, the radical right-wing bloc of the Supreme Court did Donald Trump an enormous favor, did him a real solid by conjuring up out of thin air, creating out of whole cloth, not only absolute presidential immunity, but in case that wasn't enough to protect Donald Trump, they gave him a second layer of immunity, something they call presumptive presidential immunity. And we're going to talk about those concepts in a few minutes. But what I want to do today, friends, is just focus on a little bit of the opinion, a good bit of Justice Sotomayor's dissent, and then toward the end of today's video, we're going to talk about the silver lining. Now, yes, in order to see it, you have to sort of close one eye and squint with the other and turn your head just so, but there is a silver lining. And rather than trying to cover the entire opinion today, we'd be here all day. There's a lot in there to unpack. There's a lot to dislike. There's also a little bit to like. I'll probably do a series of videos over the next 3, maybe 4 days, because I really want to focus on one discrete aspect of this opinion in each of the next few videos. So I hope you'll bear with me over the course of the coming days as I do a series of Justice Matters videos about this, pretty horrific Supreme Court opinion. But let's start with a little bit of the new reporting about this opinion, and you'll see from the cover of it, page 1, how I feel about it. But I want to start with a headline that comes from the Washington Post, and you'll see a whole series of headlines along these same lines. This from the Washington Post: justices give presidents immunity for official acts, further delaying Trump trial. And friends, here is a summary of the ugliness that this new Supreme Court opinion represents. Held. Under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. And he is entitled to at least presumptive immunity from prosecution for all his official acts. There is no immunity for unofficial acts. So that is the ugly, democracy-busting top-line takeaway from this new Supreme Court opinion that, the right-wing justices just fabricated. So basically, they break things up into 3 categories. The first they call core constitutional powers of the president and the presidency, and anything the president does that is considered an exercise of a core constitutional power, that gets absolute immunity, even if it is a stone-cold crime. And I'm going to circle back to that one in just a minute. Category number 2 is what they call presumptive immunity. Anything that a president does that is an official act, even if it's not necessarily a core constitutional power. But if it's an official act, even one that just kind of dwells along the outer fringes of a president's duties to perform those kinds of official acts. If they're official acts, well, they get presumptive immunity, and it's very hard to overcome presumptive immunity. So that's the second layer of protection for Donald Trump and other criminal presidents in the future. And then the third category, they say, well, there's no immunity for unofficial acts. You know, that was not in dispute. That was not really litigated. You know, that's like throwing a bone to a dog, but there really is no dog there to enjoy it. But they did tack on that third category. Now, mind you, there's no authority for what the Supreme Court just did, making up these three categories and bestowing either absolute immunity or presumptive immunity to a president who commits all kinds of crimes, as long as those crimes fall under either the core constitutional powers or the official duties of a president. He gets a walk. He gets a pass. He can violate all of our nation's laws, commit all the crimes he wants against the American people, but nothing can be done about it because the Supreme Court just fabricated this immunity. Not only is there no support for it, there's no case law, there's no precedent, there's no constitutional provision, there's certainly no statute, no congressionally authorized immunity for a president. There's actually contrary authority in the Constitution. The Constitution contradicts the notion that a president is above the law and immune from prosecution. And as we'll hear in a few minutes, portions of the dissent point this out. We've talked about it before, friends. The president has the constitutional duty, responsibility, obligation to take care that the laws of the nation be faithfully executed. That's kind of the opposite of, announcing that a president can violate our criminal laws with complete impunity and immunity, as long as you call them exercising core constitutional powers or official presidential acts. That's contradicted by the text of the Constitution, the express language of the Constitution. There's a second place in the Constitution that contradicts this conjured up immunity. It is the impeachment judgment clause that says even if a president is impeached by the House of Representatives and convicted in a Senate trial on those articles of impeachment, he can still be prosecuted for his crimes. Saying a president can still, nevertheless, be prosecuted for his crimes kind of is the opposite of concluding that a president can't be prosecuted for his crimes. The majority doesn't concern itself with the, express language of the Constitution. No, they were determined to, in this instance, give Donald Trump as much cover, as much protection, as much immunity as they possibly could. What I want to do now is focus at some length on the dissent. It's authored by Justice Sotomayor. It is joined by Justices Kagan and Jackson, and it is dead on the mark, right on the money. So we're going to look at a couple of portions of the dissent, then we're going to look for that silver lining, because it's there. And actually, there are two separate ways that, the lights have not yet gone out on democracy and on the hope that Donald Trump will be held accountable for the crimes he inarguably committed. Immunity doesn't mean you have a defense for your criminal conduct. It means you get a complete pass because you're above the law. With that, let's turn to the first portion of Justice Sotomayor's dissent. Justice Sotomayor, with whom Justice Kagan and Justice Jackson join dissenting, today's decision to grant former presidents criminal immunity reshapes the institution of the presidency. It makes a mockery of the principle foundational to our Constitution and system of government that no man is above the law. Because our Constitution does not shield a former president from answering for criminal and treasonous acts, I dissent. The indictment paints a stark portrait of a president desperate to stay in power. Justice Sotomayor continues, "The court now confronts a question it has never had to answer in the nation's history, whether a former president enjoys immunity from federal criminal prosecution. The majority thinks he should, and so it invents an atextual, ahistorical, and unjustifiable immunity that puts the president above the law. The majority makes three moves that, in effect, completely insulate presidents from criminal liability. First, the majority creates absolute immunity for the president's exercise of core constitutional powers. This holding is unnecessary on the facts of the indictment, and the majority's attempt to apply it to the facts expands the concept of core powers beyond any recognizable bounds. In any event, it is quickly eclipsed by the second move, which is to create expansive immunity for all official acts. Whether described as presumptive or absolute under the majority's rule, a president's use of any official power for any purpose, even the most corrupt, is immune from prosecution. That is just as bad as it sounds, and it's baseless. Finally, the majority declares that evidence concerning acts for which the president is immune can play no role in any criminal prosecution against him. That holding, which will prevent the government from using a president's official acts to prove knowledge or intent in prosecuting private offenses, is nonsensical. Argument by argument, the majority invents immunity through brute force. Under scrutiny, its arguments crumble." And the dissent goes on to talk about the responsibility a president has to take care that the laws of our nation be faithfully executed, and it talks about the impeachment judgment clause, and then it concludes that portion of the dissent by saying, "In sum, the majority today endorses an expansive vision of presidential immunity that was never recognized by the founders, by any sitting president, by the executive branch, or even President Trump's lawyers until now. Settled understandings of the Constitution are of little use to the majority in this case, and so it ignores them." And friends, there's so much more to talk about in this Supreme Court decision, and we will be talking about it in the coming days. But here is how the dissent wraps up, and boy, does it put us on notice of the stakes that are now involved for American democracy. Looking beyond the fate of this particular prosecution, the long-term consequences of today's decision are stark. The court effectively creates a law-free zone around the president, upsetting the status quo that has existed since the founding. This new official acts immunity now lies about like a loaded weapon for any president that wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation. The President of the United States is the most powerful person in the country and possibly the world. When he uses his official powers in any way, under the majority's reasoning, he now will be insulated from criminal prosecution. Orders the Navy's SEAL Team 6 to assassinate a political rival? Immune. Organizes a military coup to hold on to power? Immune. Takes a bribe in exchange for a pardon? Immune, 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 immune. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Because if he knew that he may one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That is the majority's message today. Even if these nightmare scenarios never play out, and I pray they never do, the damage has been done. The relationship between the president and the people he serves has shifted irrevocably. In every use of official power, the president is now a king, above the law. Never in the history of our republic has a president had reason to believe that he would be immune from criminal prosecution if he used the trappings of his office to violate the criminal law. Moving forward, however, all former presidents will be cloaked in such immunity. If the occupant of that office misuses official power for personal gain, the criminal law that the rest of us must abide will not provide a backstop. With fear for our democracy, I dissent. My God. So friends, could we use a little bit of silver lining right now? There are a couple of bright spots. You see, in the opinion, the Supreme Court returned the case to Judge Tanya Chutkan. She's presiding over Donald Trump's D.C. federal prosecution for his efforts to overturn the 2020 presidential election. And the Supreme Court directed Judge Chutkan to hold a bunch of evidentiary hearings to try to figure out which of the many acts alleged in the indictment, Donald Trump's crimes, which of his acts might be official acts that should have presumptive immunity, and which ones are not official acts. So what that means is, in the future, perhaps the very near future, and certainly well in advance of the election, we're going to have some public hearings exposing at least some of the evidence about Donald Trump's many crimes to try to hold on to presidential power. Here's the reporting about that. This from the New York Times. Headline, ruling further slows Trump election case, but opens door to airing of evidence. And that article begins, the Supreme Court's decision on Monday about executive immunity makes it all but certain that former President Donald Trump will not stand trial on charges of seeking to overturn the last election before voters decide whether to send him back to the White House in the next one. But the ruling also opened the door for prosecutors to detail much of their evidence against Mr. Trump in front of a federal judge and the public at an expansive fact-finding hearing, perhaps before Election Day. It remains unclear when the hearing, which was ordered as part of the court's decision, might take place or how long it would last, but it will address the big question that the justices kicked back to the trial court, which is how much of Mr. Trump's indictment can survive the ruling that former presidents enjoy immunity for official actions they take in office. And it will be held in federal district court in Washington in front of the judge, Tanya Chutkan, who was handling the case before it was frozen more than 6 months ago as a series of courts considered his immunity claims. So that's some good news, right? There will be evidentiary hearings, and we will begin to see and hear, or at least hear some real-time reporting coming out of federal court in D.C. as the hearings are being conducted. We will learn about the evidence of Donald Trump's crimes, his corrupt attempt to hold on to the power of the presidency after he lost the presidential election. Here's the other bit of good news. There was an acknowledgement in the Supreme Court opinion that certainly some of the acts that Donald Trump committed, as alleged in the indictment, are not official acts, and they enjoy no immunity. So the thing is, the prosecution will go forward. Perhaps no time soon, and perhaps not on all of Donald Trump's criminal conduct when they parse through, which of his acts were official, which should enjoy some kind of fabricated immunity, and which won't. But there will be a trial provided Donald Trump doesn't get elected in November. And that's the last piece of good news. Yes, this is a bright spot. We always knew it was up to us, to save our democracy. It was never going to be accomplished by any one prosecutor or politician or judge or special counsel. No, as is always the case, it's on us. It's on us to get to the polls in numbers too big to rig and too real to steal, and we will. Today is dark, right? Today is a dark day knowing that a president can commit all the crimes he wants against we the people with impunity in the Supreme Court's estimation, unless it was unofficial conduct, and so much of what Donald Trump did was not official conduct. It was criminal, and he ultimately will be prosecuted for it, provided we get to the polls in November, and make sure he does not retake the reins of federal power. Because justice matters. Hang in there, friends. And as always, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.